The United States Supreme Court just handed down two big rulings on a couple of varied topics, immigration and climate change. Texas deeply involved in one of them. With reaction, good morning to constitutional law attorney David Coale. Biden v. Texas. Bit of a shocker that the court sided with the Biden administration and against the states of Texas and Missouri on something called Remain in Mexico. How's that work?
Yeah, that case name, as you suggest there, could be a lot of things, Biden versus Texas. But
Right.
For an end of the court term, it's been kind of abstract and talked about a lot of grand concepts. This was very practical. The Supreme Court said, get real. Congress has required you to hold these people in the United States, but never given you the money. Thus, you have to have discretion. And it doesn't make any sense for us, the courts, to tell you to send thousands of people back to Mexico. We don't do foreign policy. So kind of at the end of the day, after a bunch of jargon, it was just, this doesn't make any sense to make you guys do this over again. Interestingly, Justice Kavanaugh crossed over this time around to join his more liberal colleagues on the bench to produce the winning opinion in this case, which is something a little out of the ordinary.
Yeah, this was basically, it was a Trump-era policy that was continued during the first part of the pandemic by the Biden administration. So the court finding that if Trump can institute a policy, Biden can reverse the policy. They're both presidents.
Yes. You got to dot your I's and cross your T's. And that was part of the issue in the lower courts, was whether or not the INS had done that. The Supreme Court, whether ICE had done that. Here, the Supreme Court said, that's the test, all right, but we got to look at it in context here, which is this mishmash of laws that Congress has passed. And in that situation, you got to defer to the executive somewhat. And this is the kind of case we're just going to give the executive the benefit of the doubt.
Yeah. Now, interestingly, some similar issues as far as executive authority of government agencies. State of West Virginia versus the Environmental Protection Agency. Fossil fuel companies basically saying the EPA does not have the authority to regulate some emissions from fossil fuel plants.
Yes, here it's the Supreme Court kind of grades Congress's paper in a lot of these cases. In the Biden case, it said your paper is a D, Congress. We can't make any sense of what your statutes are. Here they gave it a C-, but for a different reason. They said it's not a mess. It's just not clear enough. The statute where you gave the EPA power to maybe or maybe not regulate greenhouse gases basically lets it run the entire economy. And you can't really have meant that. And they get into a doctrine called the major questions doctrine, which has kind of lurked in the background of administrative law for a long time. Here, 6 justices get together, put it front and center, and say, when it's really important like this, you got to be clear in this. You can't just draft a statute that says, go do good things, EPA.
Now, if we're expecting this Congress under this president to come together and clarify the law on what the EPA can and cannot do, we're whistling up the wrong. Yeah, I mean,
it could get very warm in the meantime while we wait for that. But those are the rules. And 6 justices of the Supreme Court felt that this major questions idea was an important limit on what Congress can and can't do. It's got to do its job. It can't just say, you guys go fix this problem for us. And that has been a concept in our administrative agency law forever. As much as we rely on them, they have to have some limits or they'll eat everybody's lunch. The power will just run out of control.
Right. Yeah. So again, I guess if you're waiting on Congress, it won't be when hell freezes over. It'll be when hell melts down. David Coale.
Yes, it'll be warm for sure.
Thank you very much.
Anytime.
Well,